Hi, my name is Shanta Trivedi, and I'm an assistant professor of law here at the University of Baltimore School of Law. I'm also the faculty director of the Sayra and Meyerhoff Center for Families, Children, and the Courts. Today, we're going to talk about a concept called primary prevention, specifically in the context of the child welfare system, or as some refer to it, the family regulation system. Too often, the child welfare system tries to address problems after the fact. If a parent is suspected of committing abuse or neglect, we remove their children and place them into foster care. This approach inflicts trauma on children, parents, and communities. Despite public perception, the majority of cases in the child welfare system deal with neglect, not abuse. For example, here in Maryland, approximately 65% of reported cases in 2019 were allegations of neglect. And a large percentage of those are really poverty that is being conflated with neglect or that creates circumstances that may lead to neglect. Currently, the federal government spends 10 times more on adoption than it does on efforts that could be keeping families together. Rather than confronting the root causes of poverty and providing support within the community to address the issues that may lead to child welfare system involvement, we continue to err on the side of removal. This has led to approximately 400,000 children in foster care in this country in any given year. I'm thrilled to be here with this incredible panel to talk about the ways that primary prevention can be used in the child welfare system, or as many advocates and scholars refer to it, the family regulation system, to prevent families from being separated. Professor Matthew Fraden joins us from the University of the District of Columbia, David A. Clark School of Law. He's an expert on child welfare law and policy, and he has published widely on the subject, as well as provided testimony to legislative bodies. He also founded and directed a legal clinic at UDC where he, with his students, represented parents accused of abuse and neglect. Prior to joining the UDC faculty in 2004, Matt served as legal director of the Children's Law Center in Washington, D.C., supervising attorney at the Legal Aid Society of the District of Columbia, and associate counsel to Vice President Al Gore. Nina Villamar is chief of the Parental Defense Division at the Maryland Office of the Public Defender, a role that she's held since 2018. She leads the statewide division of 50 trial attorneys, social workers, parent advocates, and core staff in representing parents and legal guardians in Maryland Circuit Court who are involved in the family regulation system. Her introduction to and passion for representing parents in child in need of assistance and termination of parental rights hearings started in 1999 when she joined the Office of the Public Defender as a trial attorney in Baltimore City. She went on to represent more than 400 parents seeking to get their children out of foster care. Nina is also a 1996 graduate of the UB School of Law. And finally, we have Christopher Church, who is a senior director for strategic consulting at Casey Family Programs, the nation's largest private operating foundation focused on safely reducing the need for foster care and building communities of hope, which we'll be talking about today. In his role, he oversees Casey Family Programs partnerships and investments in Maryland and Delaware and supports special projects in a number of other states. Chris is also an academic affiliate and pro bono attorney with the Champs Clinic at the University of South Carolina School of Law, which partners with the local children's hospital to provide civil legal aid that addresses the social determinants of health. Prior to joining Casey, Christopher was the staff attorney at Champs, and he served as a consultant to a number of child welfare organizations. His consulting focused primarily on the use of administrative data to identify opportunities for child welfare system improvement. So now that you know who our incredible panelists are, let's begin today's discussion. We look forward to your questions and comments, which we invite you to share using the Q&A feature on your Zoom dashboard. We'll get to as many as we can. Matt, I'm going to start with you. What is primary prevention, and can you explain how it has been used in the child welfare context?
Thanks, Shanta, and thanks so much for having me. It's really a pleasure to be with you and to be with the rest of these wonderful panelists. The best way to prevent a social problem is to get out ahead of it. Right? So for example, if we want to prevent teen smoking, we don't do it by running around to street corners yanking smokes out of kids' mouths. We create after-school programs that for kids to get involved in art, and we create after-school programs for athletics. We have health education classes. We get out ahead of the smoking before kids ever start doing it. Well, today we're talking about a different social problem. We're talking about the problem of children unnecessarily and harmfully removed from their families. So the question is, how can we get ahead of the forces that generate this social problem, unnecessary harmful removals? Well, as Professor Trivedi said, lots of kids are removed from their families because they lack adequate food, clothing, or shelter as a result of their family's economic poverty. Other kids are removed because of the stresses associated with poverty that result in adverse conditions in the home. And then there are other kids who are removed from their families simply because their economic poverty, even though it's not actually harmful or actually dangerous, is inaccurately perceived to be harmful or dangerous by social services. So getting ahead of poverty is the way to get ahead of the social problem of children unnecessarily taken from their families by the state. One approach to get ahead of poverty, of course, is for parents simply to be given money. And there are some excellent initiatives like baby bonds and the concept of universal basic income, in which the government actually directs funds to improve the standard of the quality of life for families and children. Giving families money, such as by the tax credit that recently expired, makes families less poor. Money buys food, it buys clothing, shelter, transportation, childcare, the absence of which lead to removals, right? Money alleviates stress, which can result in removals, and parents who have more money and less stress can be perceived by the government in a different way than people who are in more dire straits. But lacking additional money, another approach to get ahead of poverty is to build strong communities. And I don't mean to be irreverent or to make light of the situation, but there are not many children who were removed from Scarsdale, New York, or from Roland Park here in Baltimore. Why? Well, strong communities prevent social problems like child removals because strong communities have layers and layers of social and economic insulation. Those layers of insulation prevent the need or the perceived need for removal from ever arising at all. Strong communities are marked by interpersonal cohesion and a baseline of necessary resources and infrastructure. And those factors limit the stresses and the other tangible consequences of poverty. Strong communities also prevent removals because if a problem arises in a family, the family has a broad, strong social network that they can turn to, which might obviate the need for government intervention. But it's not realistic to think that we're going to turn every neighborhood into Beverly Hills. So there's a program, for example, in South Carolina, aptly called the Strong Communities Program, that used volunteer resources and existing community facilities like libraries and community centers and schools. And what they did was they systematically connected with families of very young children. They helped the families connect to each other, and they provided or arranged direct support for the families. These are not families that are at risk. These are not families that are having problems. This is long before any of that stuff ever happens, right? Long before the teenager ever buys a pack of cigarettes and sticks one in his mouth. I mean, that's the analogy, right? And so the kinds of services that emerged were parents' nights out and play groups and babysitting pools and family activities and support from family advocates. And all of these services were designed to be universally available to families of young kids in the community so that they could have direct assistance and to connect families with one another in a way that created new norms of mutual assistance. And the results were terrific. Participation had tremendous impacts on families. Parenting stress went down. Parents' perception of their own parenting went up. Importantly, because any neighbor can call social services on any other neighbor. Thanks to this program, neighbors' perception of others' parenting improved as well, and rates of child abuse and maltreatment went down. So the short version is that poverty consigns thousands of kids to the traumas of removal and the traumas of foster care. And the concept of primary prevention tells us we can prevent that trauma. We can prevent those foster care placements by getting out ahead of poverty.
Wow, thank you, Matt. I want to turn to Nina to talk about, Nina, can you tell us who your clients are? Who are the clients that the Parental Defense Division serves? And what kind of problems do they face that might be addressed with primary prevention? Oh, Nina, I think you're on mute.
Sorry about that.
Sorry.
So the Maryland law authorizes the public defender's office to represent a parent only after a petition has been filed by DSS. So that means that the children have almost always been removed already and the family is already in the system. We represent nearly 3,000 parents in any given year statewide. Now, what the media portrays about the parents that we serve is usually sensationalistic. Right? The headlines are about the children who are being kept in cages for years, or the children who are murdered and kept in a freezer, right? And people think that those horrible scenarios represent the typical case, but that is simply not true. While there are some cases that come in for serious physical abuse, the vast majority of cases, as you said, Shanta, come in for poverty-related neglect, inappropriate discipline, or mental health-related issues. There's a way to address these issues long before DSS and the family regulation system need to become involved. So primary prevention could really have a substantial impact on the families that we serve by reducing the number of cases that are referred to DSS and ultimately end up being court involved. So all of the parents that we serve live in poverty. Many have substance abuse disorder, housing instability, mental health issues, lack of education, and inadequate family supports for things like childcare or transportation. As a result, we have a lot of cases that come in due to neglect that is directly related to these circumstances. Primary prevention can address so many of these issues before a report ever has to be made for abuse or neglect. And I thought that the best way to demonstrate this is to give a hypothetical example based on a pretty common case that would come across our desk on any given day. So let's say that a mandated reporter calls DSS to report a child who's missed 40 days of school. And when he does go to school, he's wearing dirty clothes, he's malodorous and hungry. The school has tried to contact the parents numerous times with no response. So a report is made to DSS and DSS has to investigate. And they find that the mother is a single parent who has no electricity in the home and is using candles for light and heat. She appears to have a mental health issue, and the child is not up to date on vaccines, is on the verge of failing school. The house is filled with dirty clothes and it just smells bad in there. So DSS files a petition based on medical and educational neglect and an inability to provide for the child, and the child is separated from the mother. And in order to be reunified, the mother has to address all of these issues. The case remains open for about 2 years and requires multiple court hearings and meetings and all sorts of resources. And the mother may or may not succeed in ever getting her child back. So imagine an alternative that's based somewhat on what Matthew described. So imagine the same family in the same situation, except that the mandated reporter refers the family to a community center that provides primary prevention services. So they interview the mother and determine that she has recently lost her job and has no income and is depressed. The mother is referred to mental health treatment that's provided in the community center. It's determined that the mother doesn't have a washing machine. That's why the child's clothes were always so dirty. And so there's a laundromat inside that community center. Turns out that the child is late to school because he misses the bus and he's afraid to walk to school alone. So the child joins a walking bus group that's formed by members of the community, where a group of them walk to school together accompanied by an adult. So the child then is able to arrive to school on time to eat breakfast. Turns out part of the reason that the parent is depressed is because she lost her job. Well, there's a training program, job training program at the community center, which then is able to refer her to employment agencies and such. There's also a child development class that's offered at the center so that the parent learns that at a certain age, the Child begins to have body odor, needs to shower daily and wear deodorant, right? If you can make them get in the shower. And by the way, there's a visiting nurse who comes to give vaccines. So the child is then updated on vaccines. Instead of separating this family and expending all of the resources that are used when a family is caught up in the court system, this family gets real help to solve their problems before DSS has to get involved and without having to deal with the devastation of being separated from each other. Primary prevention services would also include common issues that we see among our clients, including substance use. So there could be an evaluation and treatment process set up there, parenting classes, assistance with applying for things like food stamps, housing assistance, and health insurance. So these are the types of primary prevention services that almost all of our clients need, and that could really help make a difference in reducing the number of families who are reported to DSS and therefore prevent the separation of families.
Wow, that was a great illustration, Nina. Thank you. And just for those of you who don't know, a mandated reporter is basically everybody you think of who is in a helping profession: police officers, teachers, doctors, nurses, social workers. All the people that you would go to if you needed help are required by law to report you to child welfare if they suspect abuse or neglect. So what Nina is proposing is that instead of referring mandated reporters being forced to refer people to child protective services, they could be referred to community-based interventions such as the ones that she described. Chris, Casey Family Program supports many initiatives to improve the child welfare system and foster care. Have you implemented primary prevention strategies in your own work?
Thank you, Shanta, and I'll just add my gratitude for the opportunity to be here and be on this panel. It's I have the privilege of working with Nina and you, Shanta. It's part of my day job, and always welcome the opportunity to reconnect with Matt and hear his good ideas. So, as to the question, Casey does invest in a lot of strategies, particularly in the primary prevention space. And what I'd really like to do is talk about a particular one. And that's the idea of legal services as a primary prevention strategy. So Nina gave a nice overview of the services that might be available at a community center. And what I've been really interested in is whether a legal aid lawyer might be able to also serve in that prevention capacity. So we know from decades worth of data and decades worth of research that CPS is really overwhelmed with reports of unsubstantiated abuse and neglect. So Shanta, you rattled off a couple of those categories of mandatory reporters. And what we know is that when people do elect to pick up the phone and make a report of suspicion of abuse and neglect, it's far more likely that report will be unsubstantiated than it will identify a victim. And so this idea of legal services as a prevention strategy is really to target those unsubstantiated reports that are really fueled by deficits in the social determinants of health. At the risk of oversimplifying, when I say something like social determinants of health, I find it to be really just a fancy and perhaps more palatable way to say reports that are fueled by community and family poverty. So social determinants of health are things like housing stability, food security, income security. It's the conditions that impact where we live and where we spend most of our time. So legal aid lawyers are well positioned and have a long history of moving the needle to address deficits in social determinants of health. And so for the past few years, and this really started with my work at the CHAMPS Clinic, which is a pediatric medical legal partnership, I've really been focused on this idea that we can target legal aid to families that are at risk of CPS involvement and reduce the likelihood that they are unnecessarily reported, or that they are reported only to determine that that child is not a victim of abuse and neglect. And for me, the most effective way to do that is to get these resources in the hands of mandatory reporters so that they have more choices. And so there's two examples that Casey's currently, that I, in my role at Casey, am currently invested in that I want to share. And the first is a program called Standing with Our Neighbors. And that's a program out of Atlanta, Georgia. This is a school-based civil legal aid strategy. So SWAN has a multidisciplinary legal team that is literally embedded in an elementary school. Their primary focus is housing and domestic violence. Their real goal is trying to prevent children from moving schools due to a totally preventable housing issue that is rendering them either homeless or forcing them to move somewhere else into another school district. So they provide civil legal aid out of the elementary school to families that live in the elementary school's sort of catchment area. And as I learned more about this project, I became really intrigued about how this idea that a lawyer is right down the hall from the teachers in an elementary school might be impacting the likelihood that when they encounter family or community adversity, they now have two options. They have a great relationship with the lawyer down the hall that they can refer the family to, or if they suspect and their duty is triggered to report, they might do that. So again, adding more tools to the tool belt. And so we are currently funding an evaluation and allowing them to expand to another school that is a really high concentrated CPS neighborhood to determine, to answer those very questions. Is there any relationship between providing civil legal aid to address these issues directly to a family and reducing the reliance on CPS to have to respond to these cases of, I think as Matt described them really well, chronic community or family poverty, which again, legal aid lawyer is going to be far more prepared to address that than a CPS assessment or investigation. The results for that are really promising. I could talk about it all day, but I know that's not the idea here. The second strategy is really a medical legal partnership. Like SWAN, a medical legal partnership is just a well-established model that delivers legal aid where a lawyer is considered part of the healthcare delivery team. So just like a doctor might refer a kid to pulmonology to receive some specialized care for, say, asthma, they can also refer to a legal team in a medical legal partnership to provide a specialized service, which would be legal representation. The idea is really straightforward, right? Let's stick with that pulmonology example. If kids got really bad asthma, they can get really great treatment from a pulmonologist, right? They can get specialized medicine, breathing treatments, routine care. But if that kid's going home to a house that's covered in mold, that asthma is not getting any better. And so that's where the legal team comes in. They work hand in hand with the medical providers to resolve the conditions of the home. And of course, many other issues that come up that impact folks' health. So that model is, I believe, just as promising as the place-based education strategy of SWAN. And I really believe that every pediatric-focused medical legal partnership, of which there are many across this nation, is a child welfare primary prevention strategy, even if they don't know it. Kara Fink from the University of Pennsylvania wrote a fantastic and very digestible article on this, but it's really pretty simple and straightforward. Again, when we give people more resources to support families and more opportunities to resolve issues that are impacting their health, my hypothesis is that we're far less likely to see them downstream being reported to CPS for problems that CPS can't solve. So like SWAN, we're funding an evaluation of an MLP in Wilmington, Delaware, that is really focused and targeted on a particular geography where CPS is flooded with reports of chronic family and community adversity. Finally, I'll just mention that the Chance Clinic, in which I still volunteer, is partnering with the Access to Justice Lab at Harvard Law School to do an evaluation of this idea of whether pediatric medical legal partnerships embedded in children's hospitals can have the effect of reducing unnecessary CPS reports. And the basis of that study came out of the chief social worker at the Children's Hospital in my hometown telling me just that before our MLP existed, all they had that they could do was call CPS. They could refer to DSS and hope that the family got some help. Now they have two options. And when it's those chronic family cases, they really are picking up the phone and calling us instead of them. And so we have been told this is what's happening. We've long suspected it. And we think it's really a messaging strategy. We need to help the child welfare system or the family regulation system, and I mean that broadly, understand the value of a lawyer helping a family early on.
Yeah. Matt, under our current federal and state law, states have an obligation to make what's known as reasonable efforts to both prevent families from being separated in the first place, and then if they are separated, to then reunify them. Where do you think primary prevention fits into this requirement that states make reasonable efforts?
Thank you, Shanta. And I will say, Professor Trivedi and I are publishing an article that's coming out actually in the next couple of weeks on this very topic. The answer to the question of where does the law fit into primary prevention, or where does primary prevention fit into the law, is that our argument is that the law requires primary prevention. So as Professor Trivedi said, the law, federal law, requires that states make what are called reasonable efforts to prevent the need to remove kids from their homes before they actually remove kids from their homes. And that is a recognition of how incredibly traumatic and life-altering separation from family actually is for children. And if the state removes a child without making those reasonable efforts, they suffer a financial penalty from the federal government. But what we've argued in this forthcoming article is that it's simply not reasonable to say that you're trying to prevent a social problem unless you're trying to get out ahead of it. It is not reasonable to prevent, just as it's not reasonable to say you're trying to prevent smoking by pulling cigarettes out of kids' mouths. It's not reasonable to say that you're trying to prevent removals by engaging in last-ditch, 11th hour, Hail Mary, desperation measures to keep kids from being removed. But that's exactly what states do to prevent removals. So, for example, a family has few economic resources and a child shows up to school hungry, or a family's evicted and lives in their car. And the state's response to the concerns that they may have about the children in these families is to give the parent a list of telephone numbers for job training programs, or a referral to a parenting skills class. But even if those programs and classes are worth much, and they often are not, it's too late. It doesn't pass the laugh test to say we're trying to prevent unnecessary removals unless we get out ahead of poverty. It's not reasonable. It's not a reasonable argument to say we tried to prevent a removal if what we did was wait until the family was totally frayed and on their last legs, and then stepped in to try to help them. So our legal argument is that the law requires states to make reasonable, the law that requires states to make reasonable efforts to prevent removals requires primary prevention efforts like the ones we're talking about today. It's not reasonable to merely respond and merely react in desperation after things have fallen apart. So that's our legal theory. We think that creating wealth, creating infrastructure to get ahead of poverty is both for all in all the ways that that Nina and Chris and Shanta have talked about, not only effective but lacking those efforts, states are not complying with the law.
Yeah, and we've been talking a lot, we've sort of framed the problem that we're trying to avoid as removing kids from their parents, because we know that it has devastating effects. And many of us have been in court when a child was removed forcibly from their parents. And Nina, for those of us in our audience who don't know what that looks like, I wonder if you could tell us what a removal looks like in court. Sure. And also if you think primary prevention could make a difference to avoid the trauma that you've seen.
So in Maryland, if a child is going to be removed, most of them are removed the day before family goes to court. So I wanted to describe both types of removals, the in-court removals and the out-of-court removals. Obviously, we attorneys are not there when the children are taken from the home the day before the case is initiated. But I did have a case where the manner of removal became the subject of an appeal. And so I wanted to share that with the members of the audience here. And Christine, if you could share, well, hold on one second. Let me just go through this part. So this is a case where Child Protective Services received an anonymous call that the mother had left her 2-month-old baby home alone. CPS went to the home and saw that the baby appeared clean, healthy, happy, and safe. But CPS needed to ask the mother some questions. The mother was very reluctant to answer their questions and wanted to talk to her attorney. Unfortunately, when she called her attorney's office, she was placed on hold, and that's when things started to escalate. The CPS worker left and then came back with a police officer, which is permitted under Maryland statute. And here's how that went down. Christine, if you could share that screen. So this is a description of what happened in that case. The Child Protective Service worker explained to the Housing Authority Police that if she could just get some information out of the mom and calm her down, then maybe she'd leave the baby with her. But if not, then she was just going to take the baby. And when the Housing Authority Police knocked on the mother's front door, she asked them who it was. And when she opened the door, she saw the CPS worker standing behind them. And she told the officers that she didn't wish to speak with the caseworkers anymore and that she didn't want them in their home. So according to the CPS worker, the officers told the mother that the caseworkers wanted to ask her questions and wanted to know what was going on with her baby. The mother became upset and she knocked some pictures off the wall. At that point, police officer, and the Housing Authority Police is a police officer, restrained the mother and conveyed to the Child Protective Service worker that she was not going to get information from the mother, so she needed to decide whether to take the baby or not. The police officers held the mother down on the couch. One of them took out handcuffs, and the officer told the mother that he was going to arrest her. The CPS worker then went into the house. Sorry, hold on one second. Went into the house, woke the sleeping baby, took her away, and handed her to a student intern who ran to the car with the baby. And the mother was, of course, screaming and flailing about. And they threatened to arrest her for resisting. They threatened to arrest her for assaulting the police officer because she was trying to get out of their grip. So that's an example of a removal that can take place outside of, when the Department of Social Workers enter the parent's home or goes to the home to remove the child. It's very traumatic. It's very, it's not, what may be portrayed on TV as a calm moment when the parents are able to say goodbye to their children. I mean, these parents are fighting for their children from the get-go. And sadly, the removals that take place in the courthouse are no less devastating. Imagine that you're a mother or a father and the judge has just ruled that your children have to be separated from you for an indefinite period of time. You start to become really upset, maybe get really emotional, maybe raise your voice, and you're shushed by the sheriff, who's the bailiff, and the judge tells you that you're not allowed to act up in the courtroom, and that if you act up, and I put that in air quotes, if you act up, they might think that you're going to get violent. So the sheriff puts his hands on the handcuffs, ready to act just in case. And meanwhile, the children, if they're in the courtroom, are baffled and may not truly understand what is happening, but they know that it's something not good, right? Or they do understand what's happening. Either way, it's not a good situation for the children to find themselves in. There are a bunch of strangers around, and you're being told a million things. You're crying and you're despondent, and your children are frightened and they're despondent. And then the social worker comes because it's time to take the children and leave with them. And so they come and take the children from you, and then they leave the building and drive off with your babies. And you may or may not be allowed to know the name of their foster care providers because Maryland law does not require that they disclose that. And you may or may not be allowed to telephone them directly because that's a voluntary thing. If the foster care providers agree to it, then they can, but they don't have to agree to it. And so you're left there waiting for your summons so that you can sign up for the next hearing. And you have the social workers telling you that they need to meet with you. And that, by the way, you should call them tomorrow so that you can schedule a visit with your own child. So when children and their parents are separated against their will, it truly is heartbreaking, it's nightmarish, and it's traumatic. There is no other way to describe it. Primary prevention would remove the necessity of separating children from their parents, except for the most urgent of reasons, if we can address the problems before the need arises for them to have to be reported to the Department of Social Services.
Yeah, thank you, Nina. I had flashbacks to many moments where I witnessed removals, such as, there's nothing like watching a mother walk in with her newborn and watch her walk out without that baby. And I think for any parent or anybody who has children in their lives, even if they're not their own, the thought of walking into a courtroom with your child and leaving without them is just unimaginable. And being restrained from being able to show emotion at the fact that your child is being removed from your care and punished for showing emotion is just really process.
I like to remind fact finders and decision makers in court, if they are parents, the way it felt for them to send their child off to their first sleepover. And remember how tearful you might have become, how worried and scared you were. And that was for a happy occasion, right? It's their first sleepover. It's supposed to be fun. But still, you're worried and you're nervous. And then the child might become upset and cry and wants to call you in the middle of the night to get picked up. So imagine that kind of separation, which is for a happy reason, and then compare it to what it must feel like to be separated in such a traumatic way for such a serious and devastating reason, and that the separation is indefinite.
Yeah. And, I just want to be clear, like Nina said, there are some cases that require families to be separated. No one disagrees with that. There are cases where the state needs to intervene. But as we talked about, the majority of cases that end up in the child welfare system, the overwhelming majority are not those cases, contrary to what you might see on the news or read in the paper. And it's those latter cases, these cases that are really based in neglect or perceived neglect due to poverty. And that's where we're really focused on today. Okay. So Chris, we have an audience of amazing law students. Hello to my family law and child and the family students. How can lawyers and other players in our legal system engage in primary prevention efforts to help families?
Thanks, Shanta. Yeah, I'm going to approach this question in a sort of like if I knew then what I know now type of way, because it's the only way I can feel comfortable answering it with a straight face. Sort of reflect on my own thinking. And so, I think one of the first things that I would say is just foundational is we have to sort of constantly reflect, which is something I do, on how much of my ambition to be in this field is rooted in saviorism. And I just have to put that out there and be aware of it and try to minimize it. And just to be transparent, like I came into this field with a ton of ambition and for saving, and it's an ongoing struggle to keep that at bay. And I'm not saying there's anything wrong with having that instinct, because I think if somebody ran up and told me that's why they wanted to be in this field, I'd be happy about it, because it is a place we have to start. But turning that saviorism into a fierce hunger for justice is a path we have to get to quickly. So why is that? Why do I think that's so important? Part of it is because so much of our nation's public policy is rooted in othering. It's sort of it's got its grounding in this idea of us versus them, and that really toxic ideology. And so if you find yourself in law school or in practice or in your career at any point in your life identifying as one of those us that is going to be on the front lines advocating for them, then I think you're going to waste a lot of years doing it wrong, doing this primary prevention work wrong. And so I think once we can get past that saviorism and really find a way to be in kinship with people that are in our community, lawyers really have the power to redress some of these wrongs, and we can get right to work. And so I do say that we get on the front lines of prevention and show the value of the power of the law that can really address some of these issues. A lot of the things that Nina talked about, right? Our clients, her clients, my clients, Matt's clients, Shanta's clients, all of our clients, we're talking about the manifestations of the root causes of these problems, right? Substance abuse. These are the things that we see and we assess and can diagnose in clinical settings, right? Somebody with substance abuse, somebody that is homeless. But those are rooted in public policy choices. Those are rooted in historical racism and redlining and income inequality. And so again, lawyers are well suited to try to put folks on the path to addressing some of those issues. And that's where I think we have to use the power of the law. And even in line with that sort of remark, I guess, I just want to say one word about prevention. When we talk about primary prevention, that being, some folks in this audience, that brings to mind something very specific in child welfare. And I'm not saying that a civil legal aid lawyer that takes a housing case or takes a public benefits case, that intervention is going to somehow prevent a parent from intentionally harming their child. That's not the group of families that I'm focused on. And I think Matt phrased this really well early on. The only sort of prevention that I'm talking about trying to prevent in this context is unnecessary government intrusion into the affairs of a family. And particularly when that's targeted at families that don't have the resources to advocate for themselves and has historically been oppressed from being self-advocates. So that's really the type of prevention I'm talking about. There are parents out there that will intentionally harm their children. It's a small subset of the cases that we deal with. And I really hope that some organization is out there thinking about primary prevention in that context. And I don't really have a good idea about how lawyers can help in that context, at least not one that excites me very much. But in the overwhelming cases that are funneled through our CPS system, I think lawyers that address the social determinants of health are well suited to solve those problems and prevent families from having to go through that process. And so I hope all of the folks on this call, whether they're social workers, lawyers, any kind of advocates, really take that to heart and find ways to support families far upstream of the system, because once a call is made, our systems, the machinery is going to kick in, and it's really going to impact families.
Yeah. Gosh, my wheels are turning. Matt or Nina, do you want to weigh in on how law students, law professors, advocates, social workers, whoever may be in our audience, how can they help primary prevention primary prevention efforts?
Sure, I'll jump in. I would suggest first that if you're not already familiar with the science behind the harmful effects of the trauma of separation between parents and children, that you become educated on it. And Shanta actually has an article that I think is going to be shared with everyone. It's a great place to start to learn about it, because only when you appreciate the trauma and the long-term harm that comes from breaking up families, all in the name of saving the children, will you see the need for a different approach to helping these families. So I think that's one place to start. I would also suggest that people consider becoming engaged in efforts to create programs to help members of their community who may be in need. The saying, it takes a village. Well, it's absolutely true. And even those of us who are privileged enough to have a lot of resources, we still need help from time to time. So imagine the need among those who lack resources. The walking bus idea that I mentioned in my earlier hypothetical seems like a great program to help reduce truancy or tardiness. Holding a clinic to help people fill out applications for benefits is a real, it's a way to actually give them immediate help. Organizing a clothing drive so that people have access to newer weather appropriate clothes and shoes, so that there's no allegation of children being outdoors, not dressed warmly enough in winter. So getting involved in your own community and helping to create these programs in the community that are designed to address problems before they become problems with a capital P. And then finally, my third suggestion is to get involved in the legislative process and consider providing written or oral testimony before the legislature to allow bills that would allow the government to get more involved in the families' lives more quickly and more deeply when it may not be necessary. So, get involved in legislation, support bills that promote primary prevention services, so that we can avoid this over-involvement that the government may have into the lives of people who really are suffering from the effects of poverty and whose problems can be addressed in other ways. I don't know if the general public realizes this, but you can sign up to testify in front of the legislature and submit written testimony. So use your power and use it for good in this way.
Yeah, I love that point, Nina. And we have the benefit, in our Baltimore community of being part of a small community. You can reach out to organizations that do the kind of work that excites you, as a law student or as someone interested in these issues, and ask what legislation is happening right now. We're in the legislative session, and see if there are ways to support law students. You could reach out to your professors and say, I heard that there's this bill. Is there anything that I can do to make sure that it passes, right? There are opportunities, like Nina said, to testify either by submitting written or oral testimony, or you should call your representatives and tell them what you think they should do about the legislation that's pending. Matt, did you want to add something?
Yeah, thank you. And I'm really glad that Chris raised one of the most important issues that we hadn't talked about yet, and that's the issue of race. And it's race that underlies so many of the decisions that are made with respect to policy and practice in the child welfare system. Those of you who are involved with child welfare know this as a sad reality. Those of you who haven't been as involved may be shocked and appalled to find out that in every state in the country, every aspect of the child welfare system adversely affects people of color in a manner that is vastly disproportionate to their representation in the general population. Now, part of that, of course, is due to the barriers and economic inequities that disproportionately inflict poverty on families of color. And some of it is due to systemic racism. The Center for the Study of Social Policy has done a ton of amazing work documenting and trying to counteract the forces of systemic racism. So if the question is, what can new lawyers and what can non-lawyers do to address this social problem of children unnecessarily being removed from their families? Well, one answer, if we're asking, if removals are due to poverty and race, well, a good place to start is by looking for racism everywhere, because it is everywhere. Systemic racism is everywhere. That's why we call it systemic racism, because it's baked into our systems. So look for it and fight it in everything you do. Fight economic inequality all the time. These are the things that we can do to prevent kids from unnecessarily being harmed by being taken from their families. We can support the child tax credit. We can support the Build Back Better Act, right? Politics and elections have consequences. And so, some of the efforts that Nina was talking about in terms of the legislature, your audience matters. The audience of legislators who you're talking to really does make a difference. And so every single move we make and every breath we take is either helping or it's not helping. And so I think we can be conscious of that. I see a note in the chat from Joni Raymond that says, is there anything that can be done without the wholesale system change, universal basic income? With the systems we have for primary prevention, I see most often. And I think that the points made in that note, I think, are very well taken. That every family is different and every family is complicated. But as a lawyer, what you can do is, as bizarre as it may sound, insist that judges apply the law, because for the most part, shockingly, after what you've heard from us today, shockingly, the Constitution is actually kind of helpful. The Constitution really does say that families shouldn't be removed, shouldn't be separated unnecessarily. And all of the states have enacted statutes that that really do sort of recognize that the Constitution requires that. But when we walk into family court, we are often confronted with judges who aren't familiar with the law, who don't like to apply the law. You know, in one case that I was involved in, one of my students said, "But Your Honor, you can't remove the child until you make this finding and this finding. The law says you have to say this, and then you have to look at that." And the judge reared up and said, "In this courtroom, we don't do law, we do practice." You know, that should chill every lawyer in the audience and every law student. So as a law student, as a new lawyer, you can assume that when you go into these courtrooms, you will be knocked back. You will face lots of resistance. But if you are getting to know your clients, and if you are believing them and listening to them and learning about them and their families, if you are learning the law and insisting that judges apply it, you're going to win. I mean, you know, peck, peck, peck. You know, Richard Wexler, who made a comment in the chat, who was here from the National Coalition for Child Protection Reform, once told my students, keep banging your head against the brick wall because sometimes it moves. Keep doing it.
I have headaches from banging my head against that wall quite a bit. You know, someone asked Marissa, who I don't know Marissa, but I'm guessing you're a law student, asking where you can make the most difference as an aspiring lawyer, as a practitioner in this field. Hi, Marissa. Okay. I just wanted to say, you know, there are many career paths. Nina's office obviously represents parents in these proceedings. There are offices that represent children. There's a lot of ways to be involved, depending on what your perspective is. And I'm glad that we brought up this topic of race at the end here, but also this idea that rich people somehow elude the child welfare system. And I think it's a combination of everything we've been talking about, right? They have the material resources to never end up in the kinds of positions that we've been discussing, where their kids have no shoes or have to miss school because they missed a bus. But also there's the idea of surveillance, right? Many low-income people are just more exposed to mandated reporters, and, you know, government officials are just a part of their lives, from where they live, if they happen to live in a shelter, to where they access medical care in an emergency room, to schools. And that, combined with the bias that Matt was just explaining, leads to more intervention into those families' lives. I think we'd be remiss if we didn't say that, because they're just more public. You know, all of these issues are, whereas I could potentially, if I were yelling at my child, it'd be in the privacy of my home or my car. And because I'm wearing a suit, someone might not judge me as a poor parent. But if someone did that on the street or in a shelter or outside of a public school, you know, and that person was less educated or less wealthy, they would be perceived for the exact same behavior as being abusive to their child. I wanted to end, well, first of all, if anybody has any last words before we wrap up, I'll turn the mic over to my esteemed panel.
I just want to acknowledge and congratulate Matt for working some Sting lyrics in to his remarks. That was impressive.
I enjoyed that too. I didn't think we were going to get to the police, the band tonight. Nina, did you want to add anything before I wrap up?
I'm really excited about the question posed by Marissa about where attorneys can make a career in this field. Yes, aside from being an attorney, you could also join, public defender's office or children's attorney's office and work on the legislative end. So there are a lot of different opportunities in this field. We are in need of attorneys in this field who are interested and who care about the issues that arise in our area of work. So I encourage everyone to apply.
Yes, and I'm always happy to talk to students. If you're interested in this field, not just UBalt students, any law students out there, I love talking to students about working in this field. And I just wanted to say that at the Sayra Neil Meyerhoff Center for Families, Children in the Court, which I direct, I'm the faculty director along with Rebecca Stahl, who's our executive director. We believe that one of the simplest ways to support families so they can avoid legal system intervention in the ways that we've been describing is to make it easy for them to find the resources that they need. And that includes mental health providers, alcohol and substance use treatment programs, housing assistance, and others. And in normal times, figuring out what services are available and open can be really difficult. But in these times, it's even more so because unfortunately, so many community-based providers have had to shut their doors. And that's why we've put together a community resource guide, which highlights those service providers that are open during the pandemic and are continuing to offer services that are accessible to families with limited means who are on Medicaid or who don't have any health insurance. We've highlighted organizations that are providing services in other languages, such as Spanish, as well as those who primarily serve the LGBTQ community. This guide is a work in progress, and we will be adding more resources in the upcoming weeks, but I'm going to post a link to it in the chat. And we also wanted to let you know that if you are a part of an organization that provides the kinds of services that we've been describing, please let us know at cfcc@ubalt.edu. I'll also put that in the chat and we'll include you in this guide if you are here in Baltimore. And if you'd like to join CFCC's mailing list, register here. I wanted to give a special shout out to CFCC's legal fellows, Jillian Crescenzi and Ali Hodge for their amazing work on that guide. We hope it's helpful to those of you in the community who work with clients that could use these services. And I want to say thank you to all of you for joining us and learning more about this topic, and to our panelists for their brilliant and revolutionary ideas and their tireless work to improve the child welfare system. Thank you all very much. I'm going to put my email in the chat as well. If you have any questions, please feel free to reach out. Thanks very much.